Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. This video, I want to talk to you about your Miranda rights and your Fifth Amendment right against self-incrimination. A lot of times people will come into our office and they'll talk about, hey, I was arrested and the cops didn't read me my Miranda rights. Why can't you get the case dismissed? So-and-so said that, that I read somewhere online, or this other attorney I spoke to. And we take a step back and we go through a lot of times what people don't know, and that's understandable. When Miranda is required, when your rights need to be read to you, and what the remedy is if they're not. So let's break it down a little bit. First thing is you have a constitutional right against self-incrimination, right? You're under no obligation to talk to law enforcement whether you've done something wrong, whether you know you've done something wrong, whether you think you've done something wrong, or whether you have no idea what they want to talk to you about. You have a constitutional right to politely decline to answer any questions. That's the first step. But let's assume law enforcement wants to talk to you. Well, when does Miranda apply, right? When do your rights need to be read? Well, there's two things. Two things need to be present in order for that to happen. The first is you need to be detained. Well, if you're arrested, you're detained, right? You're not free to leave. But if you're not arrested, sometimes you're detained, sometimes you're not. And that's the first step. And there's a legal definition to that. So the context of the questioning, whether or not you're free to leave, where those questions took place, right? You can't be detained if you're talking to the cops on the phone. Well, they didn't read me my Miranda rights. Well, you weren't detained, so Miranda doesn't apply. A lot of times the cops will say, or the district attorney, prosecutor, or judges will even talk about a consensual encounter. You were free to leave. Your client was free to leave. They were not detained. So the first step is, were you detained? Second, were you under interrogation while you were detained? Were you being questioned, or were you just detained and started blurting out information? You weren't asked any questions. You just started volunteering questions, which goes back to the whole principle here. Know your rights. Understand the law as best you can. Know that you have a right against self-incrimination. Keep your mouth closed. Hope this video has been helpful understanding your Miranda rights. If you have any questions about a criminal defense case, whether or not you gave a statement or not, we are just one phone call away at 619-295-3555. 619-295-3555. Again, my name is David Shapiro, San Diego criminal lawyer.